Hello and a warm welcome to our special program on the federal, the capital beat. In all these years, chief election commissioners and the election commissioners were appointed on the advice of the Council of Ministers. Putting an end to this age-old practice, Supreme Court yesterday came out with a landmark and a historic judgment where they said that the CEC and the election commissioners will now be appointed on the advice of a committee which is going to comprise of the Prime Minister, Chief Justice of India, and the leader of the opposition in Lok Sabha. And if there is no leader of the opposition available, then the leader of the largest opposition party shall be treated as the LOP. Now, this arrangement of the committee, the Supreme Court said, shall continue till the time Parliament doesn't enact a law on the appointment of the CECs and the ECs. Now, how does one read this judgment, especially if you talk about the independence of the Election Commission? And is this judgment really not a commentary on the times we are living in? Joining me now is a very special guest, former Chief Election Commissioner, SY Quraishi, who was the 17th CEC of the country. Thank you, sir, so much for joining on the federal. And your first thoughts really on the judgment which the Supreme Court has given as far as the appointments of the CEC and the EC is concerned, sir.
This is a welcome judgment, and we had been trying to get it for the last 20 years. I've written many articles, I've spoken to the media several times, and many of my predecessors, the CECs, former CECs, from Dr. Gill onward, we have been demanding that. Although some people say, look, you were also appointed by the same process by the government of the day. But while being in office, I remember giving interviews when I was the CEC that I would have felt stronger and better in public perception if a leader of opposition was also a signatory to my appointment, because perceptions are very important, and perception of neutrality and non-partisanship is very, very crucial. And this is one step which will be in that direction.
But the ball is still in the court of the Parliament, because the Supreme Court has said that this arrangement of the committee will continue till the time the Parliament doesn't enact the law. Now, in all these years, sir, we haven't seen. There is an Article 324 in the Constitution which talks about a law like that, which should set the service conditions, the tenure and everything. But in all these years, none of the political parties have really bothered to bring out the law. How hopeful are you that the Parliament really is now going to bring out a law?
I'm hopeful that they will do it. Number one, when we say Parliament will bring out a law, it is basically the responsibility of the executive. Parliament by itself doesn't sit in a session and passes an act. The bill is presented by the executive, or leave aside a private member's bill. A bill is put up in Parliament, and has been the failure of not of Parliament but of the executive. Governments have come, governments have gone, but and this demand has been around for about 50 years. But they have not bothered. Now, if they don't bother anymore and wait for another 75 years, so let it be, because Supreme Court in its wisdom has very rightly said that till you pass the act, the rules which we have framed, the norm which we are laying down will operate. So it will be common sense, it will be in the interest of the country that the executive puts up this bill in Parliament and filled up the details, because this bill has this decision has given broad direction, but there are still many things to be decided, which can be decided through the act.
But why do you think there has been this kind of a persistent reluctance on the part of the executive? I'm not going to name any party, be it any political party, but there has been a persisting reluctance on bringing this law. Why do you think so?
I'm surprised, because the country is familiar with the system of collegium. We have a collegium system for CVC, for CIC, for Human Rights Commission. So, and even for Director CBI, but that was on the orders of the Supreme Court. Now, Director CBI is not even not a constitutional authority, not a statutory authority. He is just the head of a department. No different from Director of Agriculture or Animal Husbandry. Just because he performs an important function and his power can be abused, that is why the Supreme Court said that let there be a collegium. So now, therefore, reluctance of the government is not understandable. One obvious reason is that everybody wants the unilateral power and which they don't want to share. So, which was the reason? But the fact that the collegium system is working and working pretty well, so it should have been done.
But Mr. Qureshi, when you talk about the CBI chief or the CVC and this arrangement of selecting the CECs and the ECs will almost be similar as what you're going to select the CBI chief. But even then, there are a lot of questions on the autonomy of the CBI chief or the CVC. People still say that, CBI is under the government's thumb. I mean, there are allegations like that. So how hopeful are you that supposing if this collegium system restores the autonomy of the CEC or the EC, again, the allegations would be that, somehow the government is trying to find its own way.
Yeah, no, that's a good point. In fact, the CBI experience is always cited that despite collegium system, CBI is being abused all around to settle political scores. So what difference has it made? So that's a valid question. But at the same time, when you see a CVC or CIC, no political party has raised a finger against any of the action of those two bodies or of chairman of the National Human Rights Commission. One flaw with which was there in the case of the CBI's director's appointment, that it was decided by a majority vote 2-1. The leader of opposition had opposed it. Now, personally, I feel these decisions should be by law unanimous. Because if there is no unanimity, if leader of opposition is objecting and the government overrules because he has the second vote of the Chief Justice, so the problem will continue. So, which is why the unanimous decision is a good idea. And I'm sure in 1.4 billion people, there will be the officers who will be unanimously selected by the three members. And in any case, Chief Justice's presence is okay, but he really is not expected to know, and he is not likely to know all the background and the biodata of the person being considered. Leader of opposition will know because they worked with the civil service throughout their life. So, but Chief Justice's presence will only ensure that the process within the committee or the collegium is democratic.
But Mr. Qureshi, what I was wanting to ask you was that do you think that this judgment really will make the government bound to bring a law? Because given the fact that there has been a reluctance in the past, and what if the government doesn't bring a law? What happens then?
No, it will be embarrassing for the government because this was the mandate of the Constitution, Article 324(2), which says that the president will make an appointment on the advice of the Council of Ministers till a law is made. Now, right. 70 years down the line, 73 years down the line, law has not been made. So obviously, it has been a lapse on the part of the executive for all these years, and it cannot allow to be continued, which is what Supreme Court has flagged. And okay, let them wait for another 70 years. Till then, the norm laid down by the Supreme Court judgment will have to be acted upon. That cannot be ignored. That will be contempt of court.
You said that it would be treated as a contempt of court. But what happens if because there is no time period set as in the judgment, the Supreme Court has not defined that, look, the law has to come up within a year or within 2 years. So what happens? It's like an endless journey again. We do not know when the law.
That's exactly what I said, that the court has made it very clear that till the act is passed, the norm laid down by the Supreme Court in this judgment will continue. So the act may be passed in 6 months, in 6 years, or 60 years. Till then, the norm will continue at least for the interim period. So, the court has made it clear that this will be the norm to be followed.
So, which means that now the government has a choice after the Supreme Court judgment that either you go by the committee or you bring out the law.
Well, I think government would like to bring a law sooner than later, because there are other issues also which have been left unsolved, like removal process of the election commissioners, which was also the part of the. There were 4 petitions, mind you, 4 different writ petitions. So, and that was also a demand which has not been settled, and which, to my mind, is a big flaw in the system, and also the weakness of this judgment.
Right. So, do you think that whenever the law comes in, so the law will deal with these aspects as well, appointments as well as the removal of the CECs and the ECs?
Exactly, because they are quite interlinked, and they are very important for the objective which we seek to achieve of perception and the image of the election commission of being neutral and non-partisan. Matters like this keep going to the court. They have been going to the court for the last 70 years, and court has been adjudicating on them. So this is more in that category, and not to say that the times are bad. Well, what they are seeking to correct has been going on for 70 years. So that there was same time 70 years ago, 60 or 50 or 30 years ago as today, to single out these time as particularly bad will be wrong.
But the court did mention in the judgment that, the time is right now for the court to lay down the norms. The court is justifying that why it was forced to make a judgment like this.
Yes, because because of the delay, the constitution expected a law to be made, and for India to wait for 70 years for that, obviously is not acceptable. It's too long, and that is what court commented on, and said that the time has come and it should be done.
But what do you think, Mr. Quraishi, would be the biggest hurdle as far as bringing in the law is concerned, or restoring the autonomy of the election commission is concerned? Because a lot of questions have been raised that how independent is the EC? There were instances. In fact, I interviewed also earlier when there was an incident where the election commissioners were called in by the PMO. There was an incident like that. But so what would you really say, that can this law really restore the autonomy of the election commission?
Well, this will be the step in the right direction, because as it is under the constitution, even if appointed by the current executive, once appointed, the chief election commissioner in any case is protected from removal, and election commissioners are expected to keep an arm's length distance from the government, which is why when we joined the election commission, I was the secretary to Government of India. 1 more year to go for retirement. The day I joined, I had to resign to cut the umbilical cord with the government, which I had for 35 years, and become distant. And then, obviously, the expectation is that you work then independently of the executive, and you're not under their thumb, which is what is expected. And not only it should be legally the case, but it should appear to be so also. So optics are more important in this case. The perception of independence is more important. Well, we have a judiciary, we have a Supreme Court, and which also has a collegium. But the questions have been raised about several chief justices, their judgments. There were questions have been raised about chief election commissioner's judgment, despite the constitutional autonomy. So there, of course, there is the human element, because the institution provides you the protection. But if the individual is doesn't want to exercise that the power or independence given, so that's a matter of personal style of management, or adjudication, and personal backbone.
But Mr. Qureshi, without taking names, by and large, the image of Election Commission has really taken a beating. And I don't want to go into the reasons, but the kind of allegations that like the EC is pliable, it has been unfair, it's biased when it comes to elections. Say, for example, in the model code of conduct, the way violations are seen, but then they are overlooked. Uh, why do you think these allegations have really come up? There would be no smoke without a fire.
Well, actually, when I hear such a thing, it pains me no end. It hurts me as if it is a personal slap on my face, because I have also laid a brick or two in the construction of the autonomous body which the Election Commission is. And in our time, it was very rare that aspersions were cast on our neutrality or integrity. But and when it happens, and it happened subsequently several times, if you just analyze the newspaper headlines of the through the years, you can see. So obviously nothing is hidden, and as they say, जनता सब जानती है, जनता सब watch करती है, and that gets reflected. So it is sad, and it is incumbent on all of us to, when we find when we go to this office, we should leave the office richer and more glorious than we had found it. And if we leave it weaker and controversial, it is our human failure.
Another aspect which I wanted to speak to you about was that supposing if the law comes in, will the bill or the law, whatever comes up, we'll also talk about the financial autonomy. I'm talking about the constitutional autonomy, the appointments, the administrative part is different. But what about the financial autonomy? Should the law not deal about that aspect as well?
Yeah. I hope so, because that is a demand which Election Commission itself has been formally making for years, for 20 years, 25 years. The two things. One, that we would like the funds of Election Commission to come from the Consolidated Fund of India instead
Right.
of a budget voted in Parliament. Although personally, I feel I have been giving it a low priority. This is a demand which is more symbolic, which has more optics. That like the Supreme Court, which whose funds come from the Consolidated Fund, CAG's funds come from Consolidated Fund. Why not Election Commission? These optics are important, but
Right.
I have not made it a big issue, because during my 6 years in the commission, government never sat on our budget and did not. They gave us whatever we wanted. Though of course
Right.
there were sometimes there were delays in which we brought it to the highest authority the attention, and the funds were released. But theoretically, same MPs on whom we sit in judgment every day, they may be very unhappy with some judgment of the Election Commission. And when the budget proposal goes in Parliament, the same MP will, in his speech, will condemn and criticize the Commission before saying yes, voting for the budget. That is the point.
Right.
So it should be done. And this I was going through the judgment. The judgment has included the experience of many countries of the world,
Right.
including in the neighborhood, and everywhere it is found that there is total financial autonomy.
But you are saying that the funds really, by and large, have not been a problem. But yes, the appointments have been a sticky issue.
Yeah, yeah, there was a time when they were probably an issue. In fact, Mr. T in session had demanded money for introducing voter ID card. The Prime Minister then refused to give him the money. And he says, all right, you don't give me the money, I will not conduct the election. And that would have led to the fall of the government. Because Mr. Narasimha Rao, who had come, was a non-MP, he had to become an MP within 6 months. So immediately, now, but these types of strong arm tactics to be used is not very healthy. Government should have gracefully conceded the budget. So
Right.
therefore, Mr. Session has mentioned an incident when, for a book of worth 25 rupees, they had to write to the law ministry to seek their permission. Can we buy this book? It's ridiculous. So that kind of a situation is now behind us. Election Commission has a lot of financial autonomy. In fact, it has the power of the finance ministry within the budget. Once we get the budget, we can do what we like. So therefore, for me, it has not been a major issue.
Right. Okay. So one final question, Mr. Quraishi, that once the tenure, I mean the tenure of the current chief election commissioner, once it gets over, so maybe I think in a year's time or maybe a little more than a year, once his tenure is over, how do you see the things unfolding? The government would go in for a committee which is going to elect the new CEC or the EC, or they will probably have a law before that. We have a few sessions left before the next general election. So what do you think could be the option before the government?
The next vacancy in the election commission will be the early next year. Till then, there is no issue because no vacancy, no appointment, therefore there is no need. So hopefully, the government will move and take action to bring a bill in parliament. And till then, the court has made it clear that you follow this norm for have a collegium. And this same collegium is working in 3-4 other institutions. So it's nothing new. It is totally an experience, based on experience, and we have that entity existing.
Right. And if the government is found dragging on bringing the law, then you say that it's a contempt of the court.
Yeah, because the judgment is very clear. They said till you do that, this will operate. So this is a clear verdict of the Supreme Court, and obviously every judgment of the Supreme Court is the law of the land.
Right. But when you have a collegium system, like where we are going to have the Prime Minister, the LOP, and the CJI, during the selection process, how do you see the things unfolding? There probably would be media leaks on what the LOP is saying or what the CJI is saying, or will it not happen like that? This is a speculative thing, but I'm just asking you.
In fact, I was going to use the same word. I don't want to speculate because anything can happen. It's futile to talk about what will happen. But only important thing, which I'm very happy about, that the court has made it clear that if there is no leader of opposition, which is the situation now, because the numbers of the largest party are shorter than 10%, which is required, the leader of the largest party. Now, otherwise, government would have found that an excuse that there is no LOP. So what do we do? At least that has been taken care of because it is the spirit. Involving the opposition is a matter of spirit and not the letter of the law. In fact, if I was a decisive authority, I would have given the power, the designation of leader of opposition to the leader of the party with the second largest majority. So what does it mean? All it means is you give him a private secretary, 2 PAs, and a staff. What big deal? After all, democracy is a matter of perception, and these are the symbols of autonomy and symbols of democracy, and they should be respected. Some large-heartedness would do good to the democracy of India.
Mr. Quraishi, I haven't seen any reaction from the government saying that, look, this judgment is welcome. And in fact, there was a complete silence yesterday, of course, because of the Northeast election results, which were coming in, and BJP was in a celebratory mood. But obviously, it seems that this judgment has not been very palatable to the government.
If you see the 4 petitioners in this case, one of them was Mr. Ashwini Upadhyay, leader of the BJP. Now, if BJP is a lawyer, is a petitioner, so I cannot understand BJP's hostility to it. I don't know. I have no answer.
Okay. But indeed, this is a historic government. But Mr. Quraishi, you feel that this judgment will clip the government's wings in some way?
No, I don't think we should use these harsh words because that was not the point. It is more a question of the image of India's democracy worldwide. As I've been saying, most powerful election commission of the world, which India is, has the weakest and most defective system of appointment. And what do I mean by that? The only country where the executive appoints the election commissioners unilaterally. In rest of the world, the collegium is the minimum, or there is a select committee of parliament. In some countries, the entire parliament debates. In some countries, the parliament interviews these candidates. In some countries, there is a live telecast of the interview of these candidates for the nation to see. Now, what is the purpose and logic of all this? The whole world is doing it, and we have this system. This required to be corrected for a long time, and I hope the time has now come.
Absolutely.
We must learn, even our neighbor Nepal, which has the latest constitution, the appointment of the election commissioners there is very cumbersome in the sense that you have to have the agreement of all parties, because parliamentary committee goes into this.
Absolutely.
A country which we look down upon in our neighborhood, there is a parliamentary committee in Pakistan which has to approve and which consists of all political parties. So, bipartisan or multilateral involvement in this selection is very optically very important, in principle very important for democracy.
Thank you, Mr. Quraishi. It's always wonderful to have you on the program. And one appeal to the viewers who are watching this program, please share this video as widely as you can. Subscribe to our channel and stay tuned to the Federal. Thank you, Mr. Quraishi.
Subscribe to the Federal's YouTube page for more interesting updates.